Endorsement.
Fact finding report / endorsement at annexure A. Full stop. Next. There are rival claims as to the persons entitled to the benefits, terminal benefits of deceased Shantappa. Matter requires consideration. In the interregnum, if effect is given to the order of the learned single judge, the claim of the appellant would in effect be rendered infructuous. Full stop. Matter requires a detailed consideration. In the interregnum, the terminal benefits are of deceased Shantappa not to be released, by respondent numbers
2 and 3.
2 and 3. Let us.
Great.
Shantappa has not made any nomination in the
No, wife and children, wife and myself.
Nimesal.
Myself, my wife and Shantappa's wife and sons, we are. He has impersonated and said he is Shantappa and continue to work.
Legible counsel for the appellant submits that legible copies would be furnished.
Yes. Krupasagar Patil.
First time birthday.
Second and third, Mr. Krupasagar Patil appeared before the learned single judge.
Is right to accept notice for respondent
2 and 3.
2 and 3. No, so just out of interest, it's your case that after Shantappa died, somebody continued to work.
Sivalingappa continued in my place, saying that he is Shantappa.
He is Shantappa.
Yes. And in collusion with the JASCOM authorities.
For how many years he worked?
Lord, right from 2000 to 2014.
From 91
Lord,
he worked.
3 and 4. Respond number 3 and 4.
From
Krupasagar
1991 he
Patil.
worked, my lord.
Respond number 3 and 4.
1991 he worked, my lord. 1991 only.
Correct, but he claims.
I died in 1999.
Not you. Shantappa died. You are not claiming to be Shantappa. You are claiming to be the LRs of Shantappa. But they are claiming Shantappa is dead. Long live Shantappa. Yes, next.
Next.
soul rest in peace.
Huh?
Let Shantappa's soul rest in peace.
Lords, the petitioner
Yes.
was appointed as an assistant public prosecutor, and her daughter was ill. There was an emergency, medical emergency for the daughter. I have also submitted the prescriptions and the medical reports to show what she was suffering from. For that reason, she could not attend the court work for some days. But before she could be absent from the court work, she had sent an email saying that there is a medical emergency. Now there is an order of termination even without issuing notice to the petitioner, without an inquiry, without even considering the leave application. And this order of termination is passed after 14 days from the date of that leave application is filed. So they should have at least considered that, and they should have said that medical reasons are not sufficient to continue the. Now the learned members of the KAT have rejected the application filed by the petitioner, though it is mentioned that the medical emergency is admitted.
No, just 1 minute. Now you are out of work for since when?
From 2023.
So we'll issue notice, but it
Yes.
has to be heard.
Yes, yes.
Huh?
I cannot press for an interim order right now.
Based on this, ಇದು ಮಾಡಿದ್ದಾರೆ.
Issue notice. AGA accepts notice for respondent number 1 and 2. 1 and 2.
One and two.
List week after next.
There is some office objection with regard to the prescription of the doctor being in manuscript and the typed copy not. I think, my lord, that is something which It's not possible for me to.
Office of kept in abeyance for the present.
Other side, but Doctor,
May-
serve the copy.
Copies to
I
be
will serve
served.
it, I will serve.
Copies to be served.
Please.
My lord, if it is required, your lordships may record the statement that the petitioner is not working elsewhere. Because if at all your lordships are persuaded to set aside the order, then the question of some amount which he is entitled to during the termination period, that may come into. Though it is not a requirement in law, that is only a requirement under the ID Act.
Let us see, let us see.
Please.
Number 20, Gita, Juvenility.
Memo of calculation fresh ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ. ಬಂದಿಲ್ಲ. ಕೊಡ್ತೀನಿ.
Yes.
My lords, this is a,
My lord, here the fresh memo of calculation
I have
filed by the
submitted
advocate.
my lords.
ಇದಾರಾ?
ಕೊಟ್ಟಿದಾರಂತೆ ನಮ್ಮಲ್ಲಿ ಫೈಲಿಂಗ್ ಇಲ್ಲ. I will take and I will send it to the officials and.
No calculations.
My lords, meanwhile, an amount of 28 lakhs has been deposited, which I am entitled to receive. It's deposited in the district court. It is filed by them with a memo on 21/8/2024.
You have deposited.
Please, my lord.
And that is actually, they have deposited. The reason is, I have changed my lawyer.
Now that is not in dispute or disputed.
That is not in dispute, my
My
lords.
lord, I'm sorry to say, I'm unaware. Mallikarjun Basreddy was appearing. He just asked me that they have served the memo of calculation. It has to be confirmed by the officials. For that reason,
Correct,
1
that is
week
right.
time.
No, that will give.
Please,
But if you have deposited something that's not in dispute, she can withdraw.
I will go through and file
Password.
and submit.
Password. According
Obliged
to you, that money is deposited by them.
by them in
You
the,
will find out.
yes,
Please.
Password.
obliged.
Kitty party,
My lords, they have filed the IA for withdrawal of amount, my lords, but the liability is challenged, my lords.
On
On the
what
ground
ground?
that there is no nexus between accidental injuries and death of the deceased, my lords.
It requires, huh?
Yes, so how much they deposited?
My lords, accidental,
How much you deposited?
I'll,
50% or award amount or
my lords, if released, my lords, because this is,
how much they deposit? Full amount or 50%? Yes, Mr.
50% they have deposited.
ಆಯ್ತು ಅದ್ರಲ್ಲಿ 25% ಕೊಡೋಣ.
ಅಲ್ಲ, my
ಅದ್ರಲ್ಲಿ
lords.
50% ಕೊಡೋಣ.
My lords, there is no liability at all. ಯಾಕಂದ್ರೆ ಇದನ್ನ ನೋಡ್ಬಿಟ್ರೆ will come to the
50 ಕೊಡೋಣ.
My
ನೀವು
lords,
argument
my
ಮಾಡಿ
lord,
ಅದನ್ನ
my lord,
ಮುಗಿಸಲ್ಲ.
my lord, my lords,
ಅದಕ್ಕೆ
my lords,
pending ಇರುತ್ತೆ.
my lords.
ಸ್ವಲ್ಪ
Once it is released, it is highly difficult to, my lords, there is no nexus between the injuries and death, my lords. She was,
You are not- you
she
are-
was discharged under the improved condition, my lords. ಆಮೇಲೆ ಬೇರೆ ಏನೋ ಆಗಿ ಅವ್ರ ಡೆತ್ ಆಗಿದೆ.
Let them withdraw half of the amount. Yes.
My lords, there is,
Order A2 of 2023.
my objections may be noted, my lords, kindly.
The heard counsel for the respondent, so also the insurance company. The, it is the content of, it is content, we have perused the contents of the affidavit. It is stated that they, as per the directions of this court, comma, the insurance company has deposited 50% of the award amount, and presently the claimant, the appellant, the respondent claimants are in a deep financial distress, and the said amount may be ordered to be released subject to executing a indemnity bond. Full stop. Accepting the then counsel for the respondent reiterated the contents of affidavits. Accepting this, we find, accepting the same, comma, the in our consider view, IA 1 of 2020, IA 2 of 2023 allowed by imposing conditions. According to IA 2 of 23 is allowed in part, the respondents are permitted to withdraw 50% of the deposited amount by the 50% of the amount deposited amount by executing a indemnity bond.
And proper security also, my lords, for the
What
amount.
security? Indemnity
Any-
bond itself is a security. Indemnity bond. Yes.
In the event of
Subject to the- yes,
success, my lords, we cannot,
Subject to the outcome of the
yes, yes.
Yes.
And TCR may be called for, me. TCR may be called for. Me. TCR may be called for. Me.
This is directed to secure the TCR.
22, Ravi, Chavan,
ಇದಕ್ಕೆ ಬಂದಿದ್ದಾರೆ objection ಇಲ್ಲದ್ರೆ ಒಂದು ಬರಲ್ಲ. You are not saying request.
My lords, in IA one for condone delay application, my lord.
Now you take out notice. Issue notice on IA as well as main TCR to be summoned. Next.
till number 23,
Oblast.
Vishal Pratap Singh,
My lords, this appellant has been involved in another 302, my lords, and he is being tried in before the 5th additional session judge Kalaburagi.
Pendency of this case, huh?
Yes, my lords.
One more case.
Yes, my lord. SC number 155 of 2024. So I have to get the information and file that.
Punishable with the death.
My lords.
For that offense, punishable with the death.
No,
Punishment will be
yes,
for
subsequent-
that
Yes.
offense.
Yes.
Yes, I have no instruction, my lords. Insofar,
Just re-notify in the second week of March.
Please.
yes, another request, my lords. I have placed an application before your lordship for return of the original admission register.
Which
So,
is IA?
uh, No IA is allotted to this, but that application is before your lordship.
Original admission register of?
Original admission, I had filed a plea of juvenility, so original admission register of school admission register was retained by the sessions judge. Now, my lords, that register is before this court, I was told, by the concerned department, concerned section of the,
Yes. That is to be written.
that has to be returned.
You produced the same before the session court, huh? During the course of trial?
No, the
Yes.
witness has produced, witness.
Witness has produced.
When we have filed a plea of juvenility, my lords, this honorable court had directed to inquire about it.
SPP, yeah, oh, you have to inquire.
Yes.
Please
Please.
get instructions to
Please.
that effect.
Please.
Huh?
Please.
Yes.
The register is-
SPP is there. In the meanwhile, when the additional SPP is directed to get instructions on
Application.
on
for
the
return.
application filed by the appellant to return the original admission register.
Yes,
Yes.
Let's find out.
number 24,
That is there, my lords.
No, if they want,
Yes.
you just cross check.
Please.
Then it can be sent by.
Please. Filing objections, my lords,
Hmm.
as per the direction of the honorable court. Madam.
Yes, Mr.
my lords, this matter, the allegation is 302.
Same fit, same. Bat and this one, LPG cylinder.
LPG.
You
Yes,
assaulted
yes,
yourself,
ma'am.
Yes, yes, my lords.
And
That
Get
is
bat
what
and,
is the
LPG
prosecution's
cylinder.
case.
brutally murdered your wife.
Yes.
No, my lords, we did not do it because Lord, section 106 is invoked in this case, but the foundational fact that I was present at the house, that itself was not examined, not done, my lords. The children were not made as children who were supposed to be in the house. Their statement is not recorded. I stay in the first floor of the house.
Children were aged about.
11 years, my lords. 11 years. 11 years and 4 years. Their statement is not recorded.
Children are in the custody of?
Children are in the custody of grandmother, the mother of the appellant, who has filed an affidavit. In the affidavit itself, along with the documents I have filed.
To get instruction on that.
Yes, madam. Yes, madam.
That the children are in the custody of grandmother, the appellant's mother or
Allah.
deceased mother.
I'll get in.
Huh?
I'll get in.
Affidavit is filed, and my lords,
I'll get in.
the material witnesses are not examined. The ground floor, I was staying in the first floor of the house. So, my lords, there is no statement recorded with regard to the ground floor. In fact, the complaint filed by the sister of the deceased says that
So you
police.
are not disputed the death caused in your house.
Yes, my lords.
Brutally assaulted with that cylinder and something.
Yes, yes, my lords. So, that is the concern, my lords. The person who has done it is still,
What is your explanation? Have you filed any explanation? What is your explanation in 313? Or led any evidence?
Only denial, madam.
Then only denial.
that I was not there. I was not there in the house.
That has to be
And the
proved
moment
upon.
the incident is set have occurred, my lords, he was absconding. This is the one of the material aspect to support this particular case.
Itself is sufficient, very drunkard. Enough, ಇರ್ಲಿ ಸ್ವಲ್ಪ ಸಮಯ
Please.
ಜೈಲಲ್ಲಿ re-notify ಅಷ್ಟೇ. At the request of learned additional SPP, re-notify 2 weeks.
Number 25, K. Prasad Hegde.
Appearing for appearance. Prasad Hegde is online melody is appearing. There is a delay melody of 64 days melody in filing the appeal. The Arbitration Act.
Possible, if not, can you condone?
It can be condoned because under section 34 melody there
Let
is.
them accept notice, we'll fix a date. Because there's delay, let them accept notice.
And notice is already issued. On the last occasion, notice is ordered.
Shall we condone the delay and then post it for admission?
Please.